We are in Georgia for the sentencing phase of convicted killer Matthew Lanz. A judge deliberated for an hour and a half before convicting Lanz for the murders of Justin and Amber Hicks. Let's go back inside the courtroom now. Victim impact statements just wrapped up. Now the prosecution is making a final statement to the court.
It is by far the most heinous crime that he committed. He robbed Justin and Amber's friends of their friends with the biggest hearts, their angels on earth. He robbed the Cherokee County Fire Department from one of their brothers. He robbed Tim and Charlene of their firstborn child. He robbed Mark from his one and only child, his baby girl. Mark had already lost his wife when Amber was just 2.5 months old. Never in a million years did he think that he would repeat history like that. And Matthew Lanz robbed Jacob of his parents forever. Jacob only had 2 birthdays on this earth with his mom and dad. He didn't get to spend a single Christmas with his mom and dad that he would actually remember. He didn't get to be dropped off for his first day of kindergarten by his mom and dad. He didn't get to go to his first baseball practice with his mom and dad. He didn't get to have his mom and dad at any school function like muffins with mom or donuts with dad. He doesn't get to sit at the dinner table and do homework with his mom and dad. He doesn't get his mom and dad to teach him how to drive. He doesn't get to have his mom and dad at any graduation. He doesn't get to have his mom and dad in the bleachers of any high school games. He doesn't get to go on college tours with his mom and dad. He doesn't get to invite his mom and dad for Parents' Weekend. He won't have his dad standing beside him one day when he gets married. He won't get to have a first dance with his mom. He doesn't get to become a father and share that beautiful moment with his mom and dad. That moment where all of a sudden you really deeply understand just how remarkable your mom and dad really are and how much they love you. And most importantly, Jacob will never have a sibling. The greatest gift you can give a child on this earth is a sibling. And that it was certainly the intent of Justin and Amber is to give Jacob at a minimum 1 sibling, but I'm sure many more. And he was robbed of that opportunity. Jacob obviously has a lot of love and support, and for that I'm grateful, but you cannot replace a child's mom and dad. It's actually amazing when you look at child development, children have an incomparable bond and attachment to their parents. And this bond is so deep and so innate that it remains true even if their parents aren't the best parents. Look at kids in foster care. Parents who may have been in and out of jail, who may have struggled with addiction, who had prioritized them, and yet their children still love them and put them on a pedestal. If children like that are so deeply connected to subpar parents, think about how profound Jacob's bond was to his mom and dad. They were perfect. Their lives revolved around Jacob, and happily so. And they loved their son. The 8th Amendment is supposed to protect against cruel and unusual punishment. Unfortunately, that protection only goes one way. This defendant cannot receive a punishment that's considered cruel and unusual under the Constitution, but he sure gave Jacob one. At the young age of 2 years, Jacob was sentenced to life without his parents. He will never have his mommy and daddy back. This defendant literally tore a piece of Jacob's heart and soul out of his body, robbing him of the only thing that mattered to him on this earth. This defendant has already received mercy and will continue to receive mercy because he gets to breathe air and he gets to receive love and support from his mom and dad. He even gets to choose whether he wants to face the devastating impact that his actions created, which is what we've seen today by choosing not to be present for his sentencing hearing and choosing not to hear the victim impact statements. All of that's mercy. Mercy that Jacob doesn't get. Jacob doesn't get to hear his mom and dad. He doesn't get to see them. He doesn't get to feel their love and support. He doesn't get to breathe the same air that they breathe. This defendant does not deserve an ounce more of mercy than he's already getting. We are asking that you sentence the defendant to the maximum sentence, which is as follows. For count 1, malice murder, the state is asking for a sentence of life without the possibility of parole. For count 2, malice murder, the state is asking for life without the possibility of parole consecutive to count 1. For counts 3, 4, 5, and 6, felony murder, those will be vacated by operation of law. Count 7, home invasion, the state is asking for a life sentence consecutive to count 2. Count 8 and 9 are aggravated assault counts. Both will merge. Count 8 merges with count 1. Count 9 merges with count 2. Count 10, possession of firearm during commission of a felony, 5 years to serve consecutive to count 7. Count 11, possession of firearm during commission of a felony, 5 years to serve consecutive to count 10. Count 12, cruelty to children in the second degree, 10 years to serve consecutive to count 11. And count 13, tampering with evidence, 12 months to serve consecutive to count 12. For a total sentence of 2 consecutive life without parole sentences, plus an additional life sentence consecutive, plus an additional 20 years to serve in custody consecutive, plus an additional 12 months to serve in custody consecutive. This is the only sentence that even comes close to justice for the irreparable and permanent damage that he has caused to all those before you, to all those in the community, and most importantly, to Jacob.
Sorry, Attorney Barry, I'll hear from the defense.
Your Honor, I've been doing this for 55 years. I've seen a lot of heartbreak, pain, and sorrow brought on by tragedies such as this. As a parent, the loss of a child is almost too much to bear. Our hearts go out to the family of Justin and Amber. I have done a lot of these trials. I don't think I have seen as many people attend not only the competency hearing that we had, but also this trial. I think that certainly is a tribute to the lives of Justin and Amber. I think certainly the family should be proud of the number of people that are here and the people that want to honor them. As I said in my opening statement, this trial is about who was to blame, and secondly, why this happened. I know this court, because I know this court, you looked at every piece of evidence and rendered a verdict that you felt was fair. So now this court has determined who committed these crimes. However, we still don't know why. A lingering question in the minds of a lot of people I know. And that question of why is where we're going to ask the court for some measure of mitigation. I've dealt with this case for the last 4 years. I've dealt with Matthew for the last 4 years. I believe that Matthew had and still has a mental illness. I think our ability to consider mercy is what makes us human. And it's hard to want to give any measure of mercy in this particular case. However, we are asking the court to give whatever measure of mercy that you can for Matthew, because we still don't know why. We still don't know what a motive would be. Lead detective, when I asked him about the motive, the lights, maybe his brother who was killed after the death of his brother, he went downhill pretty quickly. All we can ask of the court is simply to consider those things that the court heard in our previous 4-day hearing concerning his mental health and what this court heard in the trial of this case. That's all we can ask. And I know the court will consider those. Thank you, Your Honor.
Thank you. Eddie Green or Eddie Horowitz, do you have any rebuttal?
No, thank you, Your Honor.
Okay.
And those were the closing statements by each side. Let us know what you think. Defense saying, please, court, consider mercy in handing down this sentence. Coming up, we're going to find out whether or not the judge does show any mercy. She hands down her sentence for Matthew Lanz. Stay tuned. We'll be right back here on Court TV. Welcome back to Court TV Live. I'm Ashley Wilcott. So glad to be with you this afternoon. Let's head back together into a Georgia courtroom for the sentencing of Matthew Lanz. Yesterday, the judge found Lanz guilty of all counts related to the shooting death of Justin and Amber Hicks. Lanz waived his right to a jury trial, so the judge was the one to determine his fate. Now, Lanz also has declined. He waived his presence for today's sentencing hearing. He's allowed to do that under the law. He did. He is not there. Let's go back in, though. The judge is ready to hand down her sentence.
We are back on the record for the state of Georgia versus Matthew Scott Lanz, 229-00922. The court, the clerk, the court reporter,
Copy.
Mr. Berry, who represents Mr. Lanz, and the state represented by Assistant District Attorneys Green and Horowitz are present here in the open courtroom. Mr. Lanz has waived his right to appear for the sentencing. I will start by saying that this is not an easy job. And I'm not saying that because I want sympathy or empathy from anyone. I signed up to do this job. I say that because there is no joy that comes in sentencing someone to the very minimum the law says will be a life sentence. There is no joy that comes from hearing from the loved ones about the devastation that has been caused in their lives. But I made a decision that I wanted to do this job. I made a decision that I wanted to do this job and that I committed to upholding my oath of upholding the laws and the Constitution of the state of Georgia, as well as the law and Constitution of the United States. And I take my oath very seriously. And there were 3 things that I committed to doing when I sought to get this job. That was to be of service, to serve with compassion, and to be just. And being just or justice looks very different in every case that comes before the court, whether it is a criminal case, a domestic case, or a civil case. Because it is very, very rare that anybody comes into this courtroom for something of joy. Whether it is a criminal case and there is a defendant before the court, or victims coming before the court, or if I'm making a decision in someone's divorce about custody or visitation of their children, or someone comes in and there is a business dispute in their livelihood, the way they feed their families, I have to decide that. As Mr. Hicks, you said something when you were here in the witness stand. You said, Judge, I know you hear a lot of cases and you see a lot of cases, and I do, unfortunately. But every single case that comes before this court is important. Every single case that comes before this court deserves the court's full attention, deserves the court's full commitment to its oath, and deserves the court's full commitment to what the court said it would do in this position. This is the community in which I live, that I chose to live. I chose to live with my family. This is a community that I love. And that's what makes this job difficult. Because what does justice look like? Every case is different. The attorneys, law enforcement, prosecution, defense, we choose to be here every day. We made this decision to do this work. It doesn't mean that it makes it easy, whether you're state or defense, in the work that we do. But we all seek to be just, to seek the truth, to take the facts and apply the laws that have been given to us with those facts, and do the best that we can do. And in doing so and not allowing, when you're making a decision, you don't leave your human side at the door. You don't leave your human side at the door. But you have to remember that you have to look at the facts, you have to look at the law, and you have to apply it. Even when it may not be the popular thing or the things that people want you to do, it's without fear or favor that we serve. And to be servants of the people. That's what makes this job difficult, because you have to separate the human emotion from the facts and the law that you have before you. But I swore an oath, and I swore an oath again to uphold the laws and the Constitution of both Georgia and the United States, and I committed to being of service, to serving with compassion, and to being just. And so in the case of the state of Georgia versus Matthew Scott Lanz, 22-900-922, the court sentences Mr. Lanz as follows. Count 1, malice murder, life without the possibility of parole. Count 2, malice murder, life without the possibility of parole. Count 2 will run consecutive to count 1. By operation of law, counts 3, 4, 5, and 6 are vacated. Count 7, home invasion, life consecutive to count 2. Counts 8 and 9, count 8, aggravated assault merges into count 1. Count 9, aggravated assault merges into count 2. Count 10, possession of firearm during commission of a felony, 5 years to serve in confinement. Count 10 runs consecutive to count 7. Count 11, possession of firearm during commission of a felony, 5 years to serve in confinement. Count 11 runs consecutive to count 10. Count 12, cruelty to children in the second degree. Count that 10 years to serve in confinement. Count 12 will run consecutive to count 11. Count 13, tampering with evidence. 12 months confinement. Count 13 will run consecutive to count 12. Mr. Lanz is adjudged guilty for the above stated offenses and is sentenced for a total of 2 life without parole plus life plus 20 years plus 12 months to serve in confinement. I'll have the attorneys look at the sentencing sheet. Mr. Berry, as far as Mr. Lanz signing, are you going to sign, or will you take it back for him to sign, or will you sign the sentence? Okay.
All right, let's bring back in Rob Corbett. Rob, you just heard she did sentence him to life without parole. Obviously, the biggest, largest penalty she could impose. What are your thoughts?
Well, it appears that she gave him every day that she possibly could. The only concessions that he could possibly have gotten in this type of case would be if the judge would have agreed to run, excuse me, at least some of the sentences concurrently, meaning that they run together, they start at the same time. The fact that you have multiple consecutive sentences, in the long run or in reality, it doesn't mean much in terms of a life sentence is a life sentence. So the fact that you have a second life sentence running consecutive to the first one isn't going to change anything for him. But in the rare instance that he is able to prevail on appeal, this would sort of ensure that he still would receive some type of lengthy sentence. The fact, as we talked about before, that he chose not to be there did not do him any favors by being present, by showing some type of contrition, by accepting responsibility. Maybe the judge would have agreed at that point to perhaps consolidate judgment so that you, in essence, serve one life sentence. But since we're not in his head, don't know what he's thinking, he may have thought it's not going to make a difference anyway, so why even be there since I'm going to receive more than likely a life sentence for this conviction.
Well, I thought it was interesting in the closing remarks, defense counsel did say, in my opinion, this is mental health. If you look at the why, and the why is why we're asking for some type of mercy from the court, Your Honor, but there was nothing presented either at sentencing or during the trial about mental health.
Exactly. And if you have a viable mental health defense, or even if there is some evidence to support mental health issues that you say it doesn't rise to the level of a defense that I could put before a jury or a judge, but there is something that shows that there is some defect, even though he would be or is competent. In my opinion, you should present that. You should bring documentation to say or to present to the court that this is what he's doing. Along with that, at sentencing, that is an opportunity for you to try to give a more complete picture of your client. So you can talk about in terms of, hey, these are the issues he faced growing up. This is how far he went in school, or this is the diagnosis that he had. And it's not being used to show or to be an excuse for what occurred, but it can be used to sort of to mitigate or for the judge to take that into consideration. And I also would have taken the opportunity to inform the judge that the fact that my client isn't present is not meant to be a disrespect to your honor in any way. I've been in that situation, so you want to do that type of tap dance, so to speak, to let the judge know that this isn't a thumb in your eye, so to speak, but these are the reasons of why he chose not to be here.
Now, that's a good point. He did not address that. Great point. Also, I do want to say he did add this to paint a picture of his client. He did say during that closing, after the death of his brother, he went downhill quickly. And I think that was the only thing I really grasped onto as, that's terrible. That may have been part of the why. But again, I don't think that this sentence is wrong given the facts of the case and the convictions that the judge had already handed down.